From the Treasure Coast Lexus Studios, it's Ask a Lawyer with attorney Stuart M. Address on WPSL. Treasure Coast Lexus, US 1, south of Midway Road.
Good morning.
Welcome back.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everybody. I am Stuart Address, and this is Ask a Lawyer, episode 13. Before we start, we have a caller. We have Marie on line 274. Hi, Marie. How are you?
Good, thank you. How are you?
I'm doing all right. How can I help you?
I'm trying to find what kind of a lawyer I would need. I believe it's civil rights, but I'm not sure. I have a hospital record from when I was in the hospital, and they have completely omitted the medications that they gave me. And in pursuit of trying to get those medications, my primary doctor said that is supposed to be in the record, and you have an issue with the hospital, call a lawyer. So I want to know, in my pursuit, they blocked my phone, and they threatened me with the police.
All right, what is it that, why is it important, just so I understand, that the medication be in some document that apparently it's not in?
Why? I want to know what they shot into my veins.
Okay, so you don't have the information, and you're
No,
trying.
they have completely omitted it from the record, and in my pursuit to get the complete record, what did you shoot in my veins, in the IV, they have threatened me with the police and blocked my number.
All right, and have you asked for a detailed bill from the hospital?
Yes.
And what does the detailed bill show? It should show everything they gave you, because God knows they want to charge you or the insurance
I was
company.
going to say somebody had to pay for it.
Right, but it's not in there either. It's some type of a cover-up. I don't know what you'd call it. But
well, we don't quite know yet until we get the facts. So let me ask you this: why did something bad happen in terms of your experience in the hospital? Why is it that you think they might be trying to cover it up?
Good question. That's what I've been trying. I want to know, what did you give me? And I have people's names, and I have administration, corporate compliance, risk management, and they have completely ignored me because I wanted to know, what are the medications? Why isn't it in the record?
What has their response been by way of explanation?
None. Ignoring me completely. Okay. And then finally I got through by calling a different hospital, and the lady at the different hospital said I said, is there something wrong with your phone? She said, no, they've blocked you.
Right. Is there something, usually given what you're saying, I begin to start thinking, medical malpractice. Is there something that went wrong?
No, but I want to know what they shot in my veins.
No, I understand that, and I would think that anybody would have a right to know what medications they were given.
Exactly. By law, they're supposed to, my primary said that should be in the record.
It should be.
And it's completely omitted, and then they've turned the tables on me, threatening me with the police and blocking my...
That's where, my red alarm bells go off in my lawyer head.
Right.
Because...
Mine too.
Okay, some of those things don't naturally progress that way. Usually, when a hospital starts threatening to call the police and blocking you, something really has happened to get them to take that action. And so it's hard for me to understand what they're so concerned about if nothing bad happened to you.
Right, but if something, not to my knowledge, but what I'm saying is irregardless.
Could it be because they can't provide the information and they know they can't provide it?
Well, the question still is, what did they do and why did they do it? And it's hard to figure out what their motivation is and what a cause of action would be. It's not a civil rights case.
Would her insurance company know?
Not if it's not in the detailed billing.
It's not in the billing either. And I was there. I know they put an IV in my...
Well, they come with a little thing like you're checking out at the grocery, and they scan your band that's on your arm, and then they scan the drug, so every bit of it should be there.
Unfortunately, The only thing I can tell you at this point is if there's something that's not in a record and there was no adverse incident, it's going to be hard, frankly, to find a lawyer because there's no injury to pursue. There's no adverse consequence to you. I agree with you that you should be able to find out everything you were given.
Should she go to the hospital and try to speak to someone in person?
No, I suspect they probably have. Do they have a restraining order?
Oh no, they just the security guards. When I got through from the other hospital that passed me through, he threatened me. He said, "If you fall here again."
If that's what's going on, if she shows up, they'll no trespasser.
Yeah, if I show up, my son said the same thing. Don't go near that hospital again because there's something fishy going on.
Let me ask you this because obviously, in an hour show, there's only so much time that we can do with this. What is it? Why do you think they gave you something and it's not in the record? Obviously, I don't know what you were in for.
Yeah, I have an idea. I was misdiagnosed. I know that because when I got the record, I saw that they had a heart rate that was normal, but when they admitted me, they said it was not normal. So I think that's their cover-up, and that's why they wouldn't put it in the record.
Right, but usually if there's a misdiagnosis, absent an adverse consequence to you, a negative consequence that harms you, you're not going to have a cause of action for that either. A lot of diagnoses when you first come in are provisional. Then they take the tests and, on discharge, you see the printout that has the ultimate diagnosis and, whatever prescriptions, if any.
Well, the ultimate diagnosis was very wrong because they said it was a rapid heartbeat and it was not. But where's my rights? I have a right to know what did you shoot in my veins.
All right. Well, you've given me a little bit more information there at the end. So if you had a misdiagnosis, what you're looking for is an attorney that practices medical malpractice. They're the only ones that might be able to get into that, dig into it, see what the misdiagnosis was and, how it may have affected you.
Where do we stand on their refusal in ignoring me to tell me what they gave me?
They'll talk with a lawyer, probably.
Yes, if it's a medical malpractice claim, that lawyer is going to be the best one to be able to advise you. There's not really a claim to try to force a hospital to tell you something they say doesn't exist. Somebody has to dig in and prove that it occurred.
Oh, are you saying that they're omitting the medications because it doesn't exist?
No, I'm saying
someone made it not
I'm
exist.
saying if they say that there's nothing to tell you, it's hard to prove that something occurred unless you really start digging in and you start doing discovery.
Well,
the only way to do that is with an attorney that handles the possible type of case you might have. And here it sounds like if there's anything going on, then maybe it's a medical malpractice claim for the misdiagnosis.
So my rights about knowing what medications they gave me are...
I'm not saying that. I'm just saying that there's no way to force a hospital who says that there's nothing missing in the record to tell you what's missing in the record. So you have to have another claim.
But someone should tell her why it's missing from her record.
No, there's not if they're saying there's nothing missing.
But there is because my son witnessed the IV in my arm.
And I understand that. But if the hospital's position is nothing is missing, we don't know what you're talking about.
No, sir. They don't have any position. They've ignored me completely.
And I'm okay.
Except with their threat. Don't call here.
I understand. I do understand. But I suspect that their position is going to be that we don't know what she's talking about. Everything is in the bill. That's my suspicion after 3 years of practicing law. And the only way to dig into that and see if there's a cover-up that they gave you something that maybe they shouldn't have given you is with another cause of action that allows you to get in for discovery. And the only one I'm hearing right now is possibly a medical malpractice claim. And so I would suggest that you find a medical malpractice attorney and have a consultation, and see what they say.
Yeah, that doesn't make sense because medical malpractice is if they cause me harm.
You're right, but you're talking about a misdiagnosis, so that's the only place I could think of to recommend that you go for a referral.
And they can request your records.
Well, right, and if a hospital, if they're requesting the records, they may be a little bit more concerned in the hospital into providing something that's false.
And they
But
still may not be able to produce those records if they're really gone.
they're not gone. The question is
No, they're
whether
not gone. I got the record, but the record does not note
I know.
pills and the
The
IV
question is whether
pills,
nothing exists or whether something's missing.
and it is missing. Because
Right, and I understand. If you were in my office as a prospective client, I would understand. I would assume that you're right. Something's missing, but I can guarantee you, from their perspective, it's going to be nothing was given. I don't know what you're talking about. Everything that we gave you is in there, and so then I have to look at, is there another cause of action that allows me to dig deeper? And the only possible one I'm hearing is medical malpractice.
Sounds strange to me because I know that they gave me stuff, and
That's the
IVs and
best.
that is
That's
a
the
witness
best
and-
advice I can give you.
Yeah. Okay. Have
All
a
right.
good day.
Thank you. Take care. I think we have Dan or Don on line one if he's still there.
Are you still there?
Yeah,
Hi there.
still
Is it
there.
Dan or Don?
Don.
Don. Okay. How can I help you?
Well, you said you've been in the business for 30 years, so I'm going to ask you a silly question.
Okay.
Do you know anything about collection agencies?
Oh yeah, we've done some collection in our day.
I'm trying to help out a friend who's at work. She had a father, came down, visited, wound up in the hospital, and of course, she did the stupid thing of giving them her phone number
Right.
because, she wanted to be noticed, God forbid something happened. Trouble is, there was some claim that went in that was mishandled by Medicare. It got screwed up, eventually got fixed, but in between, a collection agency got involved, and it's been about 3 years now, and she keeps getting phone calls.
All right.
from
That's
this
an easy
collection-
one. That's an easy one. You want to stop the phone calls, right?
Yes.
All right. And is she the responsible party, or is she just a phone number that was listed?
She was just the phone number listed.
All right. I'm going to sort of give you the suggestion I would give you if she was the one who had gotten the medical care, because it should work anyway. Under the Fair Debt Collection Practices Act, which is a federal statute, collection agencies have to stop contacting you if you tell them that you dispute the debt and not to contact you further except with a lawsuit.
She did this before.
She wrote to them in that regard?
Yeah. Well, she got a letter. She disputed it. But they've never sent a letter. They only sent one letter, and that was back in 2015.
Well, let me ask you quick. You said she disputed it, but did she dispute it and say? Did she dispute it and say, "Do not contact me again, absent a lawsuit"?
Well, I didn't know her then, and I'm just, like I said,
All
she's
right.
at work. I don't know the details, but I don't think she probably put that last
All right.
part.
Well, that's the magic stuff under the Fair Debt Collection Practices Act. I would have her write a letter, send it in a manner in which you can prove it was sent and received, that simply says, under the Fair Debt Collection Practices Act, please discontinue all contact with me except to serve me with process, which means to sue me. If
Well,
they
after 3
violate
years,
that,
wouldn't they have done that?
excuse me?
After 3 years, wouldn't that have happened already?
No, it's not if she hasn't said that. No.
And they're trying to collect. They're trying to just.
Well, what I'm saying
wear
is
you
there
down.
any time factor on collections? I mean, I thought after a year they
No,
sent her a letter
absolutely
saying,
not.
"We're gonna sue
Statute of
you."
limitations. This is a breach of contract claim or a personal guarantee, depending upon how you look at it. I'd have to look at the actual statute of limitations, but I suspect you're probably looking at it 4 years.
And then what happens?
Well, then, if no payment has been made, it disappears.
Well, sometimes they bundle these debts from multiple people and they sell them to other agencies.
Right, but
and
that has
those
nothing to do with this.
agencies-
Right,
Yeah.
that has nothing to do
Sounds
with
like
this.
a mortgage company.
Yeah, they-
in
right, and they-
All right, but let's
2008.
let's get down to the simplest factor. Right now, the simplest thing is to stop them. The way to stop them is to send them a letter under the Fair Debt Collection Practices Act. Then, most likely, they're just going to go away.
Okay, but even if she wasn't the one that was in the hospital,
I would
she
I would
gave her
still
phone
do it.
number?
Yeah,
Okay.
I would still do it, and then, assuming they continue to harass her, she may have a claim under the Fair Debt Collection Practices Act, which carries with it not only penalties but attorney's fees, and that's where you start getting attorneys interested, even if there's not a big money payday, for the potential client.
And they know that, and that's why they stop.
Right.
wouldn't the father have received a letter by now after 3 years? Or
I
do
can't.
they just call?
You're asking me to speculate. I can't.
And I'm just saying, generally speaking, collection agencies just call these days. They don't send up any follow-up letters. They just send.
It depends how reputable a collection agency. Some of them will just call you every 5 minutes.
You ever heard of Nationwide?
I've heard of Nationwide Insurance, but I don't know about collection agency.
Yeah. Well, apparently they're one of the biggest in the country.
That doesn't mean they're one of the most upstanding.
Yeah, and that's what they do for a living. So,
I don't know what was sent. I don't know what the responses have been. All I know is that if there hasn't been a letter saying stop contacting me, unless you're going to sue me,
and you said that on the phone.
It doesn't matter. That doesn't count.
Okay.
I mean, the statute is very clear. You have to send a writing. Okay, you don't have to mention the Fair Debt Collection Practices Act, but I tell everybody I talk to use those words because that tells somebody you know what you're talking about.
Okay, just say that one more time so it's clear in my head before I hang up.
I would say under the Fair Debt Collection Practices Act, please terminate all communications with me. I dispute the debt. I dispute the debt. Please terminate all communications with me unless you're going to serve me with process, which means a summons and complaint.
All right. I'll get her to do that. Thank
and
you
then if they
much.
violate it, she may have a claim, for violation of the act.
Mm-hmm. And then she can sue them.
That's right.
Okay. All right. Well, thank you for your help.
You're welcome. Take care. And I think we have Hank on line 3.
yes, Hank's still there.
Yes.
How can I help you, Hank?
How we doing? Okay. So this really concerns my daughter. It's about she's been legally married to this joker up in Tennessee, but they've been separated for like 9.5 years.
Okay.
And this guy hasn't paid a dime towards child support. She's got 3 little children. And so I guess he's been kind of hiding and dodging the child support thing. And
is there a child support order?
Well, she can't find the guy.
Okay.
He moves around from here to there in Tennessee. So we don't know how to go about, there's no dispute with the children because they had an issue about 7 or 8 years ago where it come to court, and the judge says, you can see the kids before you go back to Tennessee, which he didn't. He turned his tail and went back to Tennessee.
Okay.
But he's died, and when the judge called him on the phone to talk about the children, he never even answered, never replied, never did nothing. So I don't know what that.
Let me ask you: you're mentioning a court case. Was there a court case here in St. Lucie County?
There was concerning my daughter, and so she got in a little trouble. And the next thing you know, he shows up from Tennessee trying to take the children. Well, by the time I got through tearing him a new one in front of that judge, he drug tested the guy.
Wait, we're mixing up courts. Your daughter had some trouble. That's not family court.
It wasn't family
was there
court.
ever a family court case in St. Lucie County?
No.
Okay. Did they live in St. Lucie County together?
No.
Where were the children born?
They were born. They were born in Tennessee. See, the thing is like he got on drugs and this and that and the other, and he just left.
All right.
So he did, and then he's been hiding ever since, to not pay child support and whatnot.
Most likely,
But there's nobody making him pay, right?
There is no order
Yeah.
because there's no family case yet. Most likely, the court that's going to have jurisdiction over this is Tennessee, because that's where they were. That's where the children were born. She probably needs to contact a Tennessee attorney to file a petition for child support. That's the only way she's going to get that. Finding him is another thing, but getting a petition filed so that any child support awarded goes back to the date of filing. The first thing to do is to file something. Then there are lots of...
he showed up on Facebook saying, well, I got in an accident and I'm about to get this big settlement. So my daughter's like, well, hell, we're still legally married and he owes me like $30,000 in back child support. I sure would like to find out where he's at.
But
wait, why does he owe back child support if there's no child support order?
No.
Well, okay, so that's what I'm trying to ask you.
All right, there is no
legally
child
married, but they haven't been together 9.5 years.
No child support is owed until there's a child support order.
Wow.
There may be a moral obligation to pay it, but legally there is no child support owed until you go to court and you get an order for child support.
Now, can she claim part of his settlement?
Oh, you're
If they're
getting into
still-
areas that I don't know. I don't know.
Yeah, because she's still legally married to the guy.
Well, that we're talking about the kids. Now we're going there. She's still
Yeah, I
legally
know.
married. If
It's a
she's
mess.
still legally married, she may still be entitled to community property. So that's obviously that's a divorce action and a petition for child support.
Well, how do you divorce somebody that's in a different state?
You
And
file.
Oh, it's
find
very
the guy who divorced
okay.
him. How
Okay,
do
wait.
you
Let's
do
go.
that?
It's very easy. That's not a complicated thing. Okay, there's a federal statute which all the states are, have adopted in their own states that require each state to recognize, divorce judgments, decrees, things like that from another state. But
Okay.
the court that issues the order has to have jurisdiction. And if the children were born in Tennessee, and they were in Tennessee at the time, I believe the Tennessee court's going to have jurisdiction. So I would suspect that the thing to do is to file an action for dissolution of marriage, number one, for a divorce, and along with it, a petition for child support. And then
so
if you
the
can't
child-
find him, there are lots of ways to find people these days.
Mm-hmm.
You all may not be able to find him, but an investigator may be able to find him. Even an attorney with the resources they have may be able to find him.
Well, with the judgment against him for this child support, wouldn't the state try to find him too?
Oh, you would hope, but not really.
Not really. Okay.
Not really, no. I mean, so yeah, it's a mess, man. And she just wants to get divorced and move on. And I mean, she's raising 3 kids on her own.
Were they married in Tennessee?
They were married in Tennessee.
All right.
And like I said, she got in a little trouble, young and stupid things they do. And so she got in a little trouble, and he come down here and tried to take the kids. And I'm
I hear
like,
you.
oh, hell no. I was right there in the courtroom when he did that, and I told him, I said, he can pay for his drugs and his booze and his cigarettes and running around, but he can't pay one dime in child support. And if you can't prove it, and by God, it just shut him up. And they said, and they drug tested him right there in the courtroom.
But that was for a
Yeah.
different issue.
Well, no, he was trying to get the kids back. It was kind of a family
But
issue mixed with a
they're his
criminal
kids.
But you're talking
Yeah.
about, okay, you're talking about she got into a problem. That sounds like a legal problem. It sounds like a criminal problem, unless I'm
Right.
misreading you.
No, you're right.
So you were in criminal court, not family court.
Right.
Well, it was in criminal court, but it was on behalf of the children.
I understand that, but it's not the same thing.
Okay.
It's 2 different sections of the court. And family court here is not going to have any jurisdiction over the issue.
Well, the state had custody of the children. The children went into state custody.
Because mom was in
So-
trouble.
Well,
What?
Yeah.
Okay. This is why
complicated,
somebody
man.
needs a consultation for an hour with a divorce attorney. I still believe it's going to be a Tennessee attorney.
Okay.
Now, you're
So-
saying the state of Florida had custody over the kids at some point, but they don't anymore, right?
No, my daughter got her kids back
All right.
and all that. Okay, so yeah.
I really do believe she needs to contact a Tennessee attorney, for the purposes of filing an action for divorce and for child support.
Yeah, because the judge, after he didn't make the calls from Tennessee right to the courtroom to the judge, he just didn't call. He didn't
Right.
interact with the judge.
Well,
or
that
nothing.
happens
He
all the
just-
time.
Okay, so he went back to Tennessee and hid like the rat he is. So the problem is, the judge did say that I'm granting total custody to my daughter.
All right, see, now
So
you're
this guy-
okay. We only have limited time, but you're confusing the heck out of me,
Me
because
too.
a criminal court cannot. Well, no, seriously.
Me too. I'm serious.
A
too. It is
criminal
confusing.
court cannot grant custody.
Okay.
So there are so many facts here that are not along the typical path that somebody needs to sit down with an attorney who's going to look at the documents, look at the orders, and see what really happened here in Florida, because maybe that'll change the fact as to whether or not you really do need to use a Tennessee attorney. But I really do suspect for a divorce action and for child support, it's going to need to be in Tennessee. But
Okay,
you're
I'll
adding
check
facts
into
here that make me wonder a little bit, and so somebody has to look at all these documents.
Okay. Well, listen, you've been helpful. That's what we're going to do. I'm going
All
to get in
right.
touch with an attorney in Tennessee and here and just see what they both say.
All right.
And go from there.
Good
Thank
luck.
you so much.
You're very welcome. Okay, well that has been a good start to the program.
Woo!
We're halfway done.
Would you like a little break?
Sure, let's take a minute break and
Okay.
I can drink my make-believe water.
Do you have issues on the job with wages or overtime?
family and medical leave, disability issues, discrimination, or sexual harassment? Do you have a landlord and tenant problem or have a contract dispute? Have you been defamed or have your civil rights been violated? Hello, I'm attorney Stuart M. Address, and for more than 30 years I've been fighting for the rights of everyday people. I believe in aggressive advocacy combined with personalized attention. That means being available to my clients. It means answering emails, sometimes at 3 in the morning, and checking my messages over the weekend. It means caring about you. If you want to speak with a lawyer who will not be intimidated and who will actually care about you, call my office, Stuart M. Address, PA, at 772-781-8003, or send us a message through our website at www.stuartaddresslaw.com. We will respond to your calls and messages because we care. Our office is in Stuart, Florida.
Ask a Lawyer continues on WPSL. Phone lines are open 340-1590, 340-1590. Now back to your host, attorney Stuart M. Address.
Hello, everybody. I enjoy the phone calls. I hope they keep coming in. They make it for a lively discussion, and they take us places where we don't exactly know where we're going to go. And it's sometimes where an attorney who doesn't have cases or laws are in front of him, has to go based upon general knowledge and instinct. And sometimes the only thing you could say is, I need to read the documents. And
Because the law is pretty much black and white.
Oh, no. I'm
wrong.
Oh, goodness, no. Oh, where have you been sleeping? The law is gray.
Okay.
98% of the law is gray, and it's shades of gray. Only on the far, far corners where the intensely conservative and liberal people reside is law black and white. Okay? There's you're going to get me to a whole other area now. There's what's called black letter law. It's a misnomer. What black letter law means is that here is a principle of law that is well established. It cannot be argued.
Okay.
Now, so you have this case that falls, you believe, within this principle of black letter law. So when you file your lawsuit, why do you see 25 defenses? And the answer, because it may be black letter law, but if you take a little fact here and a little fact there, now you're into the gray. And frankly, that's just what happened with the last caller. Mm-hmm. Everything he said in addition made things more questionable, even to the point where at the end of the call, even though I firmly believe that his daughter needs a Tennessee attorney, I had to start wondering a little bit, because he's saying that a St. Lucie County court entered an order giving her custody, yet he's saying it was a criminal matter. Those two things don't make sense.
But see, maybe the county, which was going to take her child or children from her for whatever trouble she was in, gave her custody back.
Well, gave her...
And the father is still the father with the same rights as the mother.
Physical custody, but not necessarily legal.
Okay.
So that's where, even when people call my office, you start getting additional facts, and sometimes you just have to say, well, now I need to see the documents. Mm-hmm. So now it's a question of, if it sounds like a potentially good case, you've got to bring them in for a consultation in the office, because if somebody's talking to me about a non-compete, which we talked about several weeks ago, mm-hmm. without seeing that non-compete,
right.
It's very hard to advise
mm-hmm.
them. If somebody is talking to me about, I had this last week, somebody who was renting a house to own. They had a contract that's rent to own. Mm-hmm. Certain amount of the rent was going to go towards the purchase price.
Oh, you just said was gonna.
Was gonna. Right, was gonna. That's legal language. Was gonna.
But did it?
No, it didn't, because when they went to buy the house, supposedly now the guy didn't want to sell it. That seems like black letter law, until you find out that he didn't really own the house.
Oh, gee.
Somebody else owned the house, and the house was in foreclosure. So now, did he have an arrangement with the owner to rent this property so that all this was still up and up? Or was he renting property that he didn't own and just taking the money? I had to look at all mm-hmm. the documents to try to figure out what was going on.
Was he just getting the money?
No, it looks like he has an arrangement, but it also looks like the person's a con artist.
Okay.
And
Wow.
there are some mechanisms, which I told the individual, they might be able to take to still get the property themselves, a slightly higher price, and then they can go after this guy if he's worth anything.
Well, they're kind of stuck because they got some money into it.
They do. But now if there's a foreclosure sale, that doesn't matter.
Somebody else is going to own the house.
Either they're going to buy it at foreclosure at a higher price or they're going to let it go and then sue the guy. They really like the house. They think it's going to sell for a price lower than it's really worth.
Mm-hmm.
So they're going to try to get it. And then we'll figure out where we all stand.
With the other guy.
But very often you've just got to read the documents or all you're doing is BSing.
Mm-hmm.
Okay? Every attorney, depending upon the area of practice, could talk intelligently about a number of topics. But when you start going into details that you haven't looked at in a while, then the only thing you can do is you tell the truth or you BS. And speaking of the B part of the BS, we have Bulldog on line 1. Hey, Bulldog.
Excuse me with the BS. Don't equate that with me, sir.
Only the B part, only the B.
Mr. Address, I have to give you credit because I know that your wage law employment focus, but I never knew that you actually have that talent also in medical and divorce.
And you do divorce, right?
I'm gonna have
We do a little bit of divorce, yes, and we're not wage law focused. We do wage law.
Well, you should say that because I have to update my Rolodex here.
See, I'm allowed to tell you the areas of law in which we practice. I can't even use the word focus or things like that, or the Florida bar will come and grab my license.
Yeah.
Because you can only do things like that if you decide to take these tests and become certified in a particular area of law. Then you could say you're a Florida bar certified attorney, and you can say I specialize in
particular area. It's almost it's like doctors and everything. So lawyers are like doctors today, in that they focus in certain areas. I'm not a chiropractor, or I'm not a
right, and I do general civil
surgeon.
litigation, and the thing about that is you have areas that but any good general civil litigator is supposed to be able to research areas of law and understand them. It's what you've done.
Yeah, I went to corporate law, so I was not in that category. So, you had a much broader brush than I did.
I try. So, what can we help you with today, Bulldog?
Well, I just happened to think about going back to this wage and employment thing, and as you probably have noticed, a lot of people now are going on 36-hour work weeks.
Yes.
Instead of 40s, which I'm used to, at least, and then how the overtime works on top of that.
Well, it's still over 40. That's why they're going to 36, 37-hour work weeks to give them a little buffer before they get caught up in having to pay overtime.
What is the... wait, yeah. Okay, so that's written in the contract, but point of fact is, what's the advantage of going to the 36s versus the 40s? Is that medical insurance?
No, not at all. All those things, as long as you qualify as a full-time employee, sometimes even a part-time employee with 20 hours, you can get benefits.
How many hours do you need to work to be full-time? Is it 36 now?
No. There's no real distinction as to what's full-time. Okay.
Well, it used to be 40 hours.
It used to be, but we're talking about wage and hour law now, and the only answer I can give you is that if you have somebody work 9 to 5 and give them a half hour for lunch, you're at 37 and a half hours. Why do that? So if that person stays 10 minutes late each day, you haven't gone over 40 and you're not paying them overtime. You've built in a buffer. And that is why I believe that a lot of companies that are employing you as a full-time employee are doing it on a 36 or a 37 and a half hour work week so that they can have a little buffer in case somebody stays late, something happens, and they still can avoid paying overtime. Because if you have somebody scheduled for 40 hours, and as they're walking out the door, you say, hey, Jill, I need you for a second. Now you're at overtime.
Ah, yeah.
But you're supposed to call them over after they punch out.
Oh, well.
Oh, I'll sue you, that's for
Hey,
sure.
Hey, you're dating yourself there with that punch out
I
thing,
know. I
You know, but
But
the
that's
other
the
thing
reason,
is,
the only reason I can
remember
really
I
see.
was 40 salary and I'd work 60 and I wouldn't
Yeah.
get paid overtime.
Well,
Yeah,
if
I
you're
did that
exempt,
as-
then you don't need to be paid overtime. That goes into the whole exempt, non-exempt question.
Right, exactly. But if so, the non-exempt, is anyone paid under 40 or
No. Non-exempt.
It's a dollar as a dollar figure, doesn't
No,
it?
not even that. No. There are all these exemptions, okay, that say whether or not you're exempt from overtime, so you're an exempt employee. We spoke about a lot of them several weeks ago. The three major ones: administrative, managerial, and oh gosh.
I know. I just didn't get paid for a lot of overtime working
Anyway,
for that big radio
the
company.
three biggies now. They used to be you had to be paid $455 a week. You had to have certain other characteristics, like maybe supervising the equivalent of 2 full-time employees, having decision-making authority, things like that. If you met the criteria for the exemption, then you can work 100 hours in a week and you still got your salary. Okay. Now, for the major exemptions, as of this year, the threshold went up from $455 a week to I think it's like $918, more than doubled. So that was to make sure that if an employee was going to try to claim you as exempt, that you were making a high enough salary so that you really weren't being taken advantage of. But the wage and hour law in terms of exempt or non-exempt has nothing to do with how many hours you work. It has to do with the nature of your duties and responsibilities.
Okay, so in this, for instance, we'll talk about a nurse.
Okay.
All right. So a nurse is scheduled, give or take, what you said, the 37 and a half for the leeway time. And she picks up an extra shift.
Right.
She gets paid normal on that, right?
Well, she gets paid normal up until the 40, and then if she is the type if she is the type of nurse that qualifies to be exempt, then she doesn't get paid anything else. If she's not the type of nurse that can qualify as being exempt, then she gets paid time and a half over 40.
Based on that management stuff and
Right, because
being
we
in
spoke
charge
about
of people.
RNs, we spoke about LPNs, and
However, this also then increases the taxes on that income because she's already paid up, so she gets extra tax on any of the overtime.
well, sure, extra tax on extra income.
Extra,
see?
yeah.
There you go.
Oh, yes, you can't just pay somebody the overtime without deducting the payroll taxes.
Yeah.
Yeah,
And it might bump you up into a different bracket, right?
Bump me up, please. Bump me up.
Yeah.
A different bracket on the extra money that you make, past your your original salary or whatever it is.
Well, I think most people would be happy to, well, not happy, nobody's happy paying taxes, but I think most people would be marginally satisfied to pay a little bit extra taxes if it bumped them up into an extra tax bracket because they were making more money.
Well, sometimes yes, but the thing about it is I don't think it's fair in the right that you should pay extra taxes on working overtime.
That's
Why?
the dispute with Uncle Sam.
I don't understand that, Bulldog. Why shouldn't you pay taxes on money you're receiving as
earnings.
part of your working time?
Well, why are you paying extra taxes on, over the taxes that you're already paying?
I think we may be talking across purposes. You're not paying extra, you're paying more. Okay, FICA is 6.2%. Medicare is 1.45%. So if you work more hours, you get paid more money, you're going to pay the extra 6.2% on FICA and the extra 1.45% on Medicare.
On the more that you earned.
Right, but it's not like it's not like, okay, you work over 40 hours, now FICA's 10%. It's not like that.
Ah, okay.
They clear that up?
Yeah, but it just seems, and the taxes will be higher on the overtime, which is, that's a given. So
That's right. Well, the more money you make, the more money you're going to pay in taxes. That's a given. If you work 30 hours and they give you another shift and you work 35 hours, you're paying more taxes too. All right.
All right. Excellent.
All right, Bulldog. Thank you for the call. And if he's still there, I think we have Roy or Ray on line 2.
Is this Ray?
Yes, it is.
You're on.
Hi, Ray. How are you? How can I help you?
Hi, good morning, and thank you. Just a quick question. My wife and I are in our early 50s. We have no children. Our family lives up north, any family related to us. And so we're just looking for the best way should something happen to the two of us. Our affairs are in order as far as if something happens to me or to her, but not to both of us. So what would be the best direction to go? As it is, I have a note in my safe that directs who I want to have, say, my guitar or something like that.
Okay.
But to give somebody the right, which we do have a person, her brother, that we would like to handle our affairs, what is the best way?
All right. You need estate planning documents, and I can tell you that's not me at all. In fact,
Okay.
I recently had that done for myself, because I have a minor child with my ex-wife, and I wanted to make sure certain things were protected so that in the event I passed away, there was money that was going to go to him, but it would be going to him and not controlled by my ex-wife. So I got myself an estate planning attorney, and I was surprised at it wasn't a document he drew up. It was about 20, and I got him in this big 3-ring binder. A trust was created, a will was created, guardianship stuff was created. It's not that
the living will.
A living will, exactly.
Mm-hmm.
It's not that it's quote unquote complicated, because for him it was relatively simple. He deals with it every day. For me, it was beyond anything I had ever imagined, having to answer all these questions and planning for my own death. But what you need is an estate planning attorney that will look over the documents you have and tell you, are you missing item 3 and item 5, but you have the others.
Okay.
Because that's the way you're going to make sure that's protected.
And that it doesn't sit in probate for a
Right.
year.
Now, I will tell you one other thing. You mentioned something about you want to give your guitar. I know
like that.
That's something I do know about.
Okay.
And I do know that if you have a will, and the will says that personal property will be, I don't want to say dispersed, but personal property will be divided in accordance with a letter which may be found attached to this will upon my death. There's a reason for that, and that is because you don't have to run back to the lawyer every time you want to change something about who gets my guitar. You're entitled to crumple up that piece of paper,
And
burn
rewrite
it, rewrite a new one, keep it with your will where your will is going to be found. If you have an attorney, send the attorney a copy. It's a personal property declaration. It doesn't need to be a lawyer. All you have to, you can change it 5,000 times. But you should have a copy attached to your will, and you should send a copy to the lawyer who's holding the original of your will every time you do that, so that there's no dispute one day about which one is the most recent document.
All right, all right, so yeah, because my wife and I are just having a thing. Just having a piece of paper signed by a notary does not cut the probate out of it.
No, for personal property items, if you have a will that specifies that a document like that will be found with it, then yes, it does. But if you don't have a will, or the will doesn't say, go look for this document, having a piece of paper lying around on top of your desk where they find it the second, you pass away and they come in, that means nothing.
Okay. So get in touch with an estate attorney.
Absolutely.
All right, thank you very much.
You're very welcome. Well, folks, we have a few minutes left, and I must say I enjoyed this hour. I thank everybody for their calls and hope it continues. This has actually been the end of the initial 13-week Ask a Lawyer with one guest week of Ask a Rabbi. And we will be back at least for another 13 weeks. Don't all groan at once into your radio. Don't switch the dial. Don't use the remote. However it's done these days on the computer, just leave it alone and keep listening to me. So we'll be back for another 13 weeks. But now, in the few minutes we have left today...
What were you going to talk about?
Well, I was going to finish up sexual harassment.
Okay.
I was going to talk about other types of discrimination. And what I wanted to do first was just a few final words about health insurance companies that make medical decisions. That was the topic last week, in case you weren't around. And if you're not, you can find it on YouTube at WPSL's YouTube site. I had talked about ERISA statute and sections that allow you to get a copy of all documents that relate to the denial of any care, whether it's a prescription, surgery, hospitalization, whatever it is. And also to get the names and credentials of all those people involved in making that decision. And, if you Google it, you're going to find supposedly an old wives' tale, or what do they call them, an urban myth. When I was a kid, it was an old wives' tale. Now it's an urban myth. That by doing that, magically the insurance company will reverse their decision because, they have sometimes minimum wage workers looking for keywords and not people with experience. Now, it's an urban myth to the extent that it's not universally true. Frankly, I don't even think it's true most of the time, but it is true some of the time. There's always some truth in these myths. But what I wanted to let you know was I had a situation, we talked about it last week, although I wasn't specific, in my own family where we had a denial of care, which got me pissed off and led to that hour talk last week. And it led to a letter after 2 appeals were denied, asking for all these documents and the names and credentials of these people. And initially I was told, you're not entitled to that. Don't ever tell a lawyer you're not entitled to that.
I was going to say they probably didn't realize you were a lawyer.
Oh, goodness gracious. So I wrote them a letter, a nasty lawyer letter, and I quoted a couple of these sections of ERISA. And guess what? They overturned the denial of care, and all of a sudden it was approved. Imagine my surprise. So anyway, I wanted to let you folks know, in the next day or two, on my law firm's Facebook page, I am going to be posting a redacted, which means edited, copy of that letter so that you can see the ERISA sections that I quoted and the language that I used in case you ever want to do that yourself. I certainly recommend, as a first effort at fighting an insurance company that is trying to bully them with law. It comes straight out of the federal ERISA statute. If that doesn't work, you can always call a lawyer or ask a lawyer. But this way, I'm going to put it on my Facebook page so that you can grab it if you want it.
Almost like a form letter.
That's right. Obviously, my name is Stuart Address. Sometimes that confuses people because I practice law in Stuart. So I do have a Stuart address. And I am Stuart Address. And that could be a crazy riddle one day. But if you go to Facebook, it's Law Offices of Stuart M. Address. And frankly, if you just put in that search bar on Facebook, Stuart Address, look, put it in quotes. Otherwise, you're going to get God knows what with the word address.
You might be confusing the whole internet.
Yeah. But if you put it in quotes, you'll probably find me, and then you should find the law firm site. If that sounds all too confusing, go to the law firm's website where you'll find that lovely blue F that you can click on for Facebook. And the law firm website is StuartAddressLaw.com. So Stuart spelled like the city, Stuart, address just like I know where you live, ADDRESS, law, as in, well, that's what I do for a living, .com. And you'll be able to, you can click on the Facebook and you'll go straight to the firm's Facebook page. And I'm going to put it there. Hopefully, if it helps one person, then I'm frankly thrilled. And that's sort of the last word I wanted to say on the healthcare issue, with the clock ticking down. And this is not like football or basketball where you got the 2-minute warning
And it lasts
you
for
can
an
take
hour.
5 timeouts.
Yeah.
This is real.
Yeah.
So I only got a few moments left, folks. Next week, what we're going to try to do, and I don't mind being interrupted by the questions. I actually prefer it because we never know where we're going to go. We're going to try to finish up our discussion about sexual harassment. We're going to talk very briefly about other forms of discrimination under Title VII and how a lot of the same rules apply. And then we're going to go into some, other interesting areas for brief periods of time, such as listen to your attorney and all the pitfalls if you don't listen to your attorney. I'll give you some examples then, not now. We're going to talk about mediation. What is it? How does it work? Why do it? What are you going to get out of it? And by the way, in Florida now, as in many states, if you file a civil lawsuit before you go to trial, mediation is required. It's mandatory. So might want to try it early on.
I've got a question for you on
Sure.
that. When you get called for jury duty and you're sitting in that big room waiting to find out what's going to happen the whole day, are there people in mediation at that point? Is that what's...
Not typically. They may be huddling in the hallway trying to settle their case.
Okay, but that happens where
Me-
they go,
yeah.
well, we don't need you today because
Right.
everyone...
Mediation's been done, but
Okay.
that doesn't mean you can't stop talking settlement. And we're also going to talk about arbitration. And what is the difference between mediation and arbitration? There are some very important differences. And, we'll talk about that a little bit. And I have some war stories that might be of interest, but I think that's sort of, we're running
Yeah.
out of time. Of course, the producer's telling me, I got to speak really quick or they're going to music, they're going to have that arm thing and pull me off the stage. So, hey, I'm Stuart Address. Thank you for listening. I'll talk to you next week. It's my law office is 781-8003. And thank you for listening to Ask a Lawyer. Have a good weekend.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.